Hello, my name is Barry O'Connor. I'm an attorney that's licensed to practice in the state of California. I've been practicing law for over 25 years, and I've been a landlord for over 41 years. I'm going to talk briefly about leases. The importance of a lease is it guarantees certain rights and liabilities and responsibilities for both the tenant and the landlord. By having a lease, a landlord knows that he's going to have a tenant in his property for a certain period of time. You may not be served, if you are a tenant, a 30-day notice or a 60-day notice while you're still in a lease. If the lease expires or is about to expire, you can be given notice that the landlord or the property manager does not want to renew the lease. But during the lease period of time, if you fail to pay the rent, which is a breach, you may be given a 3-day notice to pay rent or quit. Also, if there's certain covenants in a lease that have been breached by the tenant, the landlord may serve either a notice to quit based on the breaches of covenants or a notice to perform covenant or quit. Again, a lease gives written guarantees to both the plaintiff and the defendant of certain responsibilities, liabilities of both parties. It's very important that you read a lease before you sign it because it is binding. If you end up in court, most parts of the lease are going to have some impact on what is going to happen in the courtroom. If you sign the lease that states the rent's due on the first of the month, the rent is due on the first of the month. If it states there's a grace period, that means that during the rental period of the first of the month through whatever the grace period is, the rent's still due. You won't be charged a late fee. But if you don't pay within that, you may be charged a late fee. Again, if you don't pay after the first of the month and the rent's due on the first of the month, you may end up getting a 3-day notice to pay rent or quit. On the same token, the lease sets forth certain rights that the landlord has and certain liabilities. And the landlord is responsible in most cases of paying for the taxes, the insurance on the property, and possibly water and trash. If it states that, then the landlord is liable for it. If it states that the tenant has to pay those, then the tenant is liable for it. So again, it's very important that you read a lease before you sign it. Most leases also have covenants that state that if there's a prevailing party in a civil action or a trial, then the prevailing party is entitled to attorney's fees. So it's important again that you read every page of the lease, you initial every page of the lease, and you sign every page of the lease that requires a signature. If a lease is not signed by the parties to be charged, then the lease is not binding. That doesn't mean you don't have to pay rent, doesn't mean you don't have to move. It just means it's an oral contract versus a written contract. And a lease can either be a month-to-month tenancy or it can be a fixed term. A fixed term is usually from 1 year to the next year. A month-to-month tenancy runs from month to month, which means that either party in the first year may give a 30-day notice and terminate the lease. If it's a month-to-month tenancy and a tenant has lived there for more than a year, they're entitled to a 60-day notice. If it's a lease for a term, your term lease cannot be terminated unless it's for cause.